Thank you. I'm Emily Saunderson. I'm a barrister at Quadrant Chambers, and I practice in commercial dispute resolution. I specialise in claims involving banking and finance, fraud and insolvency, and the title of this QBiT talk is What is a Claim in Debt? Now, I can hear you thinking, how hard can this be? If someone owes you money, you've got a claim in debt. And why does it matter in any event? Well, it matters very much. It affects what you have to plead, it affects what you can claim, what you can't claim, the sort of evidence that you put forward to prove your claim. It really is very important. And also, it can be surprisingly tricky at sometimes, as we're about to see. So just to give you an indication of where I'm going with this talk, I'm going to talk to you under two headings. The first is, how do you identify a claim in debt? And the second is, what do you have to prove to succeed in a debt claim? And how does that compare with a damages claim? So firstly, how do you identify a claim in debt? Well, there is a fundamental distinction between a claim for money as a debt and a claim for money as damages. And to work out whether you're dealing with a claim for money as debt or damages, you have to understand the difference between two different sorts of obligations that arise: primary obligations and secondary obligations. In a contract, primary obligations are the obligations the parties agree to between themselves. Secondary obligations are the obligations imposed on the parties by law for breach of the primary obligations. So if a primary obligation is to pay money, you're looking at a claim in debt. If the primary obligation is to do something else, such as to deliver some goods, and the party doesn't do what they're supposed to do, the goods aren't delivered, you're looking at a claim in damages. The breach of the primary obligation in that sort of case gives rise to a secondary obligation, which is to pay compensation for failing to comply with your primary obligation. That's a damages claim. Now, this primary-secondary obligation analysis comes from a very famous case called Photo Productions and Securicor, and it's an analysis that was put forward by Lord Diplock. Right, I can see you thinking, yes, I get all that, so really, how hard can this possibly be? Well, let me give you some examples. How about a case where you've got a charterer of a vessel who is obliged to, by the contract of hire, to pay a fixed sum to the vessel owner as compensation for any delay in loading or unloading the cargo, a demurrage claim? Now, that's an obligation on the charterer to pay money to the owner, and if the charterer doesn't pay demurrage, the owner brings a claim against them, and it's a claim for money. So is that a debt claim? Well, emphatically no, it is not a debt claim, because the primary obligation on the charterer is to load and unload the vessel in a timely fashion. The demurrage that's due represents an estimate of the loss to the owner for the breach of that primary obligation. In other words, demurrage is a liquidated damages claim. It's not a debt. So a claim for money is still a claim in damages if the money is payable as compensation under the contract for breach of some other obligation. Let me give you another example. What about a contract of indemnity, an insurance contract? Now, I own a car. I've got motor insurance for my car, as you do. If I back my car into a lamppost in Inner Temple car park, which would be a catastrophe because I really like my car, my insurer has to pay for the repairs to my car. That's an obligation on the insurer to pay me money, isn't it? So can I sue the insurer if they don't make that payment in debt? Again, no, I can't. Because under an insurance contract, the primary obligation of the insurer is to hold the insured harmless for the risk that has been insured against. So in my example, paying for the repairs is a secondary obligation on the insurer. It's a payment of compensation because the insurer has not prevented me from backing my car into a lamppost. That might sound a little bit contrived, but there is plenty of law on insurance. One example is a case called the Italia Express, which was a marine insurance case involving a ship being scuttled. And it was argued in that case that it would be preposterous to say that the insurer's primary obligation was to prevent a ship from sinking. It gives rise to all sorts of images of Lloyd's underwriters in scuba gear holding the ship up to stop it from sinking. But it turns out that that is exactly what is happening in a contract of insurance. It's a legal fiction. The insurer's primary obligation is to hold the insured harmless for the risk that has been insured against. So from my example, the insurance company should have stopped me from backing into the lamppost. The payment for my car repairs is their compensation for breach of their primary obligation to stop me damaging my own car. So, third example, how about this? What if you go to your bank and you want to get some money out of your account, and your bank says, no, I'm sorry, we've frozen the account, we can't do that. If you bring a claim against your bank for payment of that money, is that a claim in debt? Absolutely, it's a claim in debt. When you pay money into your bank account, what you get in return from the bank is a promise for them to repay you that money. So if the bank isn't going to repay you, you bring a claim against them, and it's a claim in debt. That's a good point for me to move on to my second heading. How do you prove a claim in debt, and how does that compare with how you prove a claim in damages? Well, a claim in debt is much easier to establish than a claim in damages, and there are 4 reasons for that. Firstly, with a claim in debt, you don't need to prove causation and loss. Secondly, you're under no obligation to mitigate the loss. Thirdly, the rule against penalties doesn't apply. And fourthly, you can get damages for late payment of a debt, but you can't get damages for late payment of damages. Now let's just unpack that a little bit. Firstly, you don't need to prove causation or loss. If you're owed money under a contract and your counterparty hasn't paid, you don't have to show that their failure to pay has caused you loss. It flows as a matter of common sense from the nature of the obligation and the breach. They simply owe you the money, and that is it. So going back to my banking example, if you wanted to take the money out of your bank and you got money in cash, you put it on the floor and you set fire to it, the bank can't turn around and say, well, actually, we've caused you no loss because you were going to set fire to that money. You'd have lost it anyway. That is not a defence. If you are owed money, it makes no difference to your claim what you were planning to do with the money. The only important thing is that the money was owed and it wasn't paid. You don't have to show that their breach has caused you any loss. Secondly, unlike in a claim for damages, you're under no duty to mitigate your loss. So again, from my banking example, it's no good for the bank to say, fair dues, we haven't paid you any money, but you should have gone out and you should have earned some more money to make up for the loss we've caused you. That is not a defence to the claim. If they owe you the money, they owe you the money, that's it. There is no place for mitigation in debt claims. Thirdly, the rule against penalties doesn't apply to a debt claim. Now, the rule against penalties is essentially that if a contract provides that a party in breach has to pay a certain amount of money to the other party as compensation for the breach, if that amount is excessive, in other words, if it's much too high as an estimate of the actual loss that would be caused to the innocent party, the court won't uphold that clause in the contract. It will say it's a penalty. Now, that obviously doesn't apply to a claim in debt, because a debt claim isn't any sort of compensation. It's a different sort of claim. Fourthly, and finally, you can get damages for late payment of a debt, but you can't get damages for late payment of damages. So going back to my banking example again, if you wanted to take some money out of the bank and you were planning to use that money to invest in some high-yield fund, and there was some sort of time restriction, so the fund would only accept deposits over the next 2 weeks, you can say, because of that late payment, the fact the bank wasn't paying me the money it owed me, I have also lost over here damages because I would have invested in this high-yield fund, but I wasn't able to do so because of this late payment of debt. Now, for that damages claim, you do have to show causation and you do have to show loss, so you have to prove that you would have put the money in and what would have happened to that money. But you can bring the damages claim for late payment of the debt. It's very well established that you cannot claim damages for late payment of damages. And the case you want to look at for that is called President of India and Lips Maritime Corporation. So in summary, what you have to do is identify whether you've got a claim in debt by working out whether the primary obligation that's been breached is genuinely an obligation to pay money. If it is, happy days, you don't have to prove causation, loss or damage, there's no need to mitigate, you can simply seek to recover the money that you're owed. And that is a whistle-stop tour to the issue of what is a claim in debt.